You know in your heart of hearts that you have a great case, a great medical malpractice case. So why is it that shortly after starting your lawsuit, after we have confirmed that you have a valid case, and the defense approaches me to try and settle your case, I turn around and say, no thank you? You want to know the answer? Come join me for a walk at the tip of Manhattan as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, you brought a lawsuit against your careless doctor claiming that, number one, he violated the basic standards of medical care, causing you harm and injury, and that your injuries are significant and permanent. Now, you know that you have a fantastic case. Your attorney has told you that you have a good case. Your attorney has told you that a medical expert has determined that you do have a very good case. So now, shortly after starting your case, I get a call from the defense attorneys to say that they would like to start negotiating and try and settle this case now at the very beginning rather than waiting 2 or 3 years down the road. And you know what I say to that? I say, sorry, I can't do it. Why would I ever turn around at the very beginning of your case and not go ahead and try and enter into settlement discussions with the defense? I'll share with you why. At the very beginning of the case, in all likelihood, the defense will have no possible way of knowing what the full extent of your injuries are. The defense will have no possible way of knowing the full extent of what medical care and treatment you have received in the past, as well as what medical care and treatment you're going to need into the future. The defense will have no clue, no idea about what the specific claims are that we are making against the various doctors and hospital staff. And that's because at the very beginning of the case, we will not have had an opportunity to exchange detailed itemized documentation showing exactly what our allegations are. The defense at the very beginning will have no idea. The only thing that they're going to know about is their conversations with their own clients. They will have had an opportunity, or they should have had an opportunity, to go ahead and discuss this matter with their own clients. That is the viewpoint that they are coming at. Now, if they believe that something was done wrong and they want to go ahead and start entering into settlement discussions, the first thing that's going to happen if we agree that yes, okay, we'll go ahead and start talking, is that they will want to see documentation about what medical care and treatment you received. They will want to know exactly what injuries you suffered. And the way to do that is by providing them with copies of your medical records, by providing them with permission slips that we call authorizations, that will allow the defense to go ahead and get copies of your medical records directly from the various doctors and hospitals where you receive treatment, because they want to be able to verify. They won't take our word for it, and they won't accept our version, our copies of the records. So they will take our copies, but they will say, you know what, give us the permission slips, we want to get them directly from your doctors, and then we'll evaluate them. In addition, at the very beginning of the case, the defense will have absolutely zero authority to actually go ahead and make an offer of any amount of money. Now, this is more of a fact-finding mission for them when they approach us and say, hey, we'd like to try and negotiate. Why? Because they want to see a couple of things. They want to see whether or not, number one, we're interested in trying to talk at an early stage. Number two, they want to see that we've gotten all of your medical records. Number three, they want to see whether or not we've spoken to a medical expert, which in our case, the answer is absolutely yes. In fact, it's a requirement in New York that we obtain a medical expert to review your records in a medical malpractice case. So they want to see all of that. Once we have provided all of those details and information, the defense will be in a much better position, a more educated position, to have a meaningful conversation and meaningful discussions. But the moment they come to us and say, hey, we think this case should be settled, well, how much do you need to settle this case? No, that's not going to happen yet. It'll happen at a later stage, but at the very beginning, at the very outset, as much as you would like to get this done and over with immediately, the reality is they have no idea. And it's only after they learn the extent and details of what we are claiming, and only after they learn the details of the specific injuries you have and the limitations and the restrictions and disabilities you suffer, can they actually make a proper assessment as to what they believe the damages are worth in your particular case. So why do I share this quick information with you? I share it with you just to open your eyes, to help you understand how these types of cases work in the state of New York. There's so many people who turn around and say, you know what, I'm going to go ahead and sue my doctor for all of these injuries. And now I expect them to go ahead and start negotiating immediately after we go ahead and start this case. Well, that's not how it works. if they had all those details and all the information at the very beginning, even then they would be reluctant to go ahead and start negotiating. They want much more information. They want to be able to conference this case with their principals, and then they would have an intelligent conversation with us about trying to settle this case at an early stage. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.